It really kind of depends on the terms in the declaration of condominium. There are some areas that are spelled out for maintenance and who's responsible for the maintenance and the replacement and the repair of items within the Florida condominium statute, but those are pretty limited. So, and usually there's a clause in the statute when you're looking at those Florida statutes regulating condominiums that refers you to the governing documents. So the first place that you go, if you're an attorney and you're looking at this issue and you're trying to evaluate it, is they will have under the definition of what is a unit. What are the boundary lines of a unit? So the unit owner is typically responsible for damages that occur within the unit and the association for things that are outside the unit. Typically, there are some exceptions to that, but just generally speaking, that's how it works. And so you look and it gets pretty complex, which is why you should have an attorney look at it, because there are things called parametrical boundaries, which kind of define where the unit begins and where it ends, and that is the obligation of the unit owner. And if it's something that is outside of that boundary, even though at first glance it may look from a common sense perspective to be within the unit, it may be something where if you look at the parametrical boundaries and you look at the definition of what is a unit and what is common elements or limited common elements and whose responsibility those are, it's not always clear. Or it may be clear that actually even though common sense would dictate it's a unit owner's responsibility, it may in fact be the associations or vice versa, depending on how the governing documents read. So it's really important to be able to interpret those. You also too, a lot of times there will be definitions, but then it gets kind of tricky because in the Declaration of Condominium, it'll say for unit boundaries, it'll say see attached. And then you have to look at the attachments at the end of the declaration. And sometimes there will be some pictures or some maybe not quite legal surveys as far as, it would go to be a recording or to close on a piece of property, but something where you would have either a site plan or you would have it spelled out so you could actually see where the boundary is from a visual standpoint. So you have to look at what it says in the writing as far as the definition, and you have to look at the attachments. So it does get quite complicated as to whose responsibility damage may be, especially if it's one that's kind of a close call. Maybe a wall that leads to the exterior. It may be plumbing that services one unit, maybe plumbing that services more than one unit, but it's running inside this wall. And so those analysis need to be made by professionals, by attorneys that know what they're doing, as opposed to a board member that may not have any kind of training in that, or a member that thinks it's the association's fault and then tries to interpret it themselves. I think you're kind of destined for trouble on that end. So I think you need to speak to an attorney that practices in those areas, and even sometimes on those, I'll give opinions and say it's not really a black and white issue. Here are the pros to your case, here are the cons to your case, and so we kind of fight it out on that, and that's why attorneys get paid to kind of parse the words and parse the attachments that are there to really come up with whose obligation it is to repair or replace if there's damage that occurs.